signature of a third party, the principal or the applicant. So as you can see from this definition, it doesn't have to be a bank that issues a guarantee. It could be an individual issuing a guarantee, or it could be a corporate issuing a guarantee. But today we're really going to focus on bank guarantees, where you are the issuer of the guarantee. So given by one party, the guarantor, you would be the guarantor to another party, whoever you're issuing the guarantee to stand behind the obligations, current and future, of the person applying to you for the guarantee. So that could be one of your customers, or it could be another bank that asks you to issue a guarantee on its behalf. So in effect, the guarantor, which is you, the bank, agrees to compensate the beneficiary for loss up to a specified amount when the principal defaults or fails to fulfill his obligations specified in the guarantee. So this is something I always highlight, that bank guarantees cover non-performance. And if there is a claim under a bank guarantee, then something has gone wrong. In other words, non-performance has occurred or default has occurred. And consequently, legal disputes are not uncommon to try and stop payments being made by banks. So if you think about it, if you are the guarantor issuing this guarantee and you're doing it on behalf of your customer, and then you receive a claim under this guarantee, does your customer want you to pay that claim? Quite likely not. He may claim, oh, it's not a valid claim, I didn't default, I didn't do anything wrong, you shouldn't honour that claim. And he may go to court, he may try to get an injunction, stop you from paying. So that is one of the biggest risks when dealing with these products, is that there will be disputes, or there almost certainly are disputes, because there is an underlying default in a contract or a failure to fulfill obligations. And so therefore, it's quite possible that there will be an attempt to stop you making payment. And that can be a problem for the bank. So when we look at bank guarantees, we say that they are independent undertakings. They're independent of the underlying contracts, and therefore banks should pay them when they receive a claim. They should be irrevocable. Irrevocable means they can only be cancelled with the agreement of all parties. So they should be irrevocable, and they should be independent of the contracts to which they relate. Now, whether they're unconditional or not, they may be conditional, they may be unconditional. So they could be either. And an example then of an unconditional guarantee would just simply be a claim, a statement of claim from the beneficiary, and that would be all that is required to draw the guarantee. And it would be very difficult in that situation for the applicant to disagree with that. For conditional ones, sometimes additional documents are called for as evidence that non-performance has occurred. So you may call for copies of bills of lading, for example, if it related to a trade transaction, or some other document might be required when there are some conditions associated with the bank guarantee. From the bank's perspective, we certainly prefer unconditional, because unconditional is much cleaner from the bank's perspective. The bank does not want to be in a position where it has to decide whether or not non-performance has occurred. The bank just wants to pay against the documents called for in the guarantee. So it simply acts against the documents. It's not interested in the in what has actually occurred in the underlying contract. So that's why it's an independent undertaking. So an independent and irrevocable undertaking from a bank, who is the guarantor, an assurance to the beneficiary whereby the bank replaces the credit worthiness of the applicant with its own. So this is one of the main reasons that people ask for bank guarantees, is that they could accept a guarantee from the corporate or from the individual, but perhaps they're not confident about their credit standing. So therefore they would like to have their credit standing replaced by that of the bank, similar to what you see in a documentary credit. So by having a bank issue the guarantee, the credit standing is enhanced, or the credit risk in the transaction is reduced from the beneficiary's perspective. Now, the last point here, payable on demand. On presentation of a written demand, so that would be a unconditional guarantee, or for a conditional guarantee, written demand and documents by the beneficiary as per the terms and conditions of the guarantee. So that really highlights the difference between conditional and unconditional. I'll just pause there, see if you're okay with that, and whether you have any questions at this stage.
No questions in the chat, Roger.
Okay. So types of guarantees. So one of the first things that we do as banks when we're asked to issue a guarantee is we have to decide whether it's a financial or non-financial guarantee. Why is this important? It's important because of the capital required to support financial versus non-financial guarantees. So financial guarantees carry a capital risk weighting of 100. Non-financial guarantees have a 50% capital weighting, so they consume less capital. So whenever we are asked to issue a guarantee, we need to know what type of guarantee we're issuing, because that will affect the pricing. Yeah, because if you're comparing apples and apples, you should charge twice as much for a financial guarantee as you would charge for a non-financial guarantee, because it consumes twice as much capital. So capital, as you know, is the bank's shareholders' funds and retained earnings. And every bank has a limited amount of capital, which it can use for entering into obligations and loans, and has to set aside capital for those transactions. So it's good news when you have a transaction that only consumes 50% of the amount of capital versus a similar transaction. So that is why we need to know financial or non-financial. So some examples of financial is examples there, guaranteeing a financial obligation, such as payment under a bill of exchange, payment under a purchase contract, or rental or leasing agreements. They are all examples of where it would be a financial, or perhaps where you are guaranteeing the facility of another, guaranteeing a credit facility for another bank to make a loan to your customer in another country, perhaps. That would also be a financial guarantee. So it's security for financial obligations, and the trigger event is non-repayment in the case of financial performance. So the customer failed to repay the loan, or the customer failed to pay the bill of exchange on maturity, or failed to meet his obligations under the purchase contract, or didn't pay his rent or leasing payment on time. So they're all financial obligations, and the trigger would be non-payment. Whereas for non-financial guarantees, they cover non-financial type situations, such as performance bonds or bid bonds for contracts. So where perhaps a customer has bid for a contract to carry out some work on behalf of say the government issues a contract for some a new road, and the customer bids to do that work, he has to issue a bid bond perhaps, and then when he wins that bid, he maybe then has to issue a performance bond, and then once he's done that and completed the contract, he maybe has to issue a warranty bond that says that the road will stay in good repair for the next 5 years. He will be responsible for any problems in the next 5 years. So they are all non-financial types of obligation. They're related to the performance under a contract. So they would be classified as non-financial. So some of the most common types of bonds and guarantees that we come across. So the first one I just touched upon, registration guarantee, bid bond or tender bond. So that's where you have a customer that is wanting to bid for a contract, and the condition of bidding for the contract is that a guarantee or bid bond be put up in place. Typically the percentage amounts for something like that are usually up to 5%. Perhaps of the contract value. So if the contract was 100 million, in order to bid for the contract, you'd need to put up a bid bond or tender bond for 5 million. So that just gives then the comfort of the person issuing that contract to know that you're serious, that you have the financial wherewithal to be able to go ahead with the transaction if the contract was awarded to that party. Otherwise, it's too easy for people just to bid for contracts, but they really are unable to fulfill their obligations, and so they're not serious. They just put in a bid and they just cause time and effort for everybody to assess their bid, and then when they win the bid, they aren't actually able to go through with it. It would waste a lot of time and energy of everybody. So this would act as compensation in the event that they were unable to move forward to the next step, which would be a performance bond. If the contract was awarded to that individual company, the next stage might be that they need to issue a performance bond to say we can fulfill the contract, and that would typically be for an amount of somewhere between 10 to 20% of the contract value, to say that we actually are able to perform under this contract, and this is our guarantee that says you can now do a full assessment of our bid. You know, spend a lot of time and effort doing due diligence and checking us out because we're confident we can perform under the contract. So once the contract's been awarded, the performance bond is required for somewhere between 10 and 20% of the contract value. Now, in some cases, the next one, advance payment guarantee. This is actually the other way around. This can be a little bit confusing, but the person that is winning the contract. So let's say you have a customer that is going to build a road and he wins a contract to build the road. Well, the person awarding the contract might have to make an advance payment. So let's say it's the government that's awarded the contract. The government has to make an advance payment to your customer so that he can finance the building of the new road or bridge, whatever it might be. Now, before the government is prepared or willing to make the advance payment, an advance payment guarantee would be required from your customer to the government to say, when we receive this prepayment, in the event that there is a default later on, you can reclaim back under guarantee. You have the bank obligation to pay you under the guarantee if your customer fails to perform under the contract. So he can get, in other words, the government can get his 20%, 30% deposit back that he has paid to your customer in the event that he fails to So they are not uncommon. They're quite common, advance payment guarantees, especially for infrastructure type projects. Then the next example, retention bond and warranty bond, they're both similar. They're where the contract has been completed, the works have been completed, but there is some obligation on the contracted party to maintain or guarantee the work for a period of time. So maybe guarantee the work for 3 years or guarantee the bridge for 10 years, that it won't have a problem. And so therefore, again, a warranty bond or a retention bond, a percentage value, maybe 10%, for example, might be required. The whole idea of these bonds here that we're looking at is to replace the need for payments. So you could easily cover these requirements by paying cash, but of course the customer doesn't want to pay cash because he's limited in the amount of cash flow that he's got, and so therefore he prefers for a bond, a bank guarantee, to be issued instead of having to pay cash. So these really replace the need for cash payments. A customs bond, that could be where goods are being imported and there is duty on the goods that are being imported, but again the customer doesn't have the cash to pay for the customs duty immediately but needs to clear the goods. In that case, a customs bond would allow the goods to be cleared, and if he doesn't pay the customs duty within the next, say, 60 days, then there could be a claim under the customs bond. That would be an example of a customs bond. That would be a financial guarantee. Shipping guarantee, we saw that in trade finance. Sometimes that documents don't arrive in time. Goods arrive before the documents. So if the goods arrive, but there's no title documents, or the title documents have not yet arrived, the bills of lading have not arrived, or the multimodal transport documents have not arrived, before the carrier or the shipping company will release the goods to your customer, the importer, they will say, we need a guarantee, we need a shipping guarantee. And they're not happy to accept your customer's guarantee. They want a guarantee from an independent third party of good standing, and so they look for a bank to issue the shipping guarantee. So that's another common type of guarantee that the bank may issue. And then the last one, collateral guarantee, is really to replace the need for security. So rather than giving physical security of a mortgage over land or over a property or over cash, making a cash collateral, you can use the guarantee as an alternative. And again, of course, that would be a financial guarantee in that case. So lots of different types that you may come across, and not all of these are trade related. Some of them are not trade related. Collateral guarantees, not trade related. Customs bond, possibly trade related, may not be trade related. Advance payment guarantee, quite likely not trade related, or performance bonds, not trade related. So some are trade related, some are not trade related. And what I said right at the beginning of today's session was that sometimes makes it difficult for banks to decide, well, where does this product sit? Who's responsible for this product? But really, you do need to have somebody responsible for this product. I highly recommend that there be a product area that is responsible for this product, overseeing this product, because revenue opportunity, that's one thing, but also because you need to make sure that the operational procedures, the legal procedures and everything are also in place and are done by people that are familiar with these types of instruments. So they need to be well managed internally within a bank. This product needs to be well managed, so it should be under a product area and the responsibility of a specialized team of people or individual who's familiar with this type of product. Any questions at that point?
questions, Roger? I think so.
Okay, so the next then question you may encounter, or the next situation you may encounter, is direct or indirect guarantees. So let's first of all look at direct guarantee. What is a direct guarantee? A direct guarantee is a demand guarantee issued directly to the beneficiary by a bank. So if you issue a guarantee directly to a beneficiary in your country, just between you and them, that's a direct guarantee. Or maybe you might issue it cross-border, a demand guarantee issued directly to the, because it's cross-border, in other words, an international transaction, you might need to send it through an advising bank, and the role of the advising bank is to authenticate the guarantee, then advise it on to the beneficiary. So either of those two types of guarantee are direct guarantees. There is only one guarantee, and it's either going straight to the beneficiary in the first example there, or it's going through an advising bank, as in the second example there. So that is a direct guarantee. However, what you will also encounter is indirect guarantees. And what are indirect guarantees? Well, indirect guarantees are counter guarantees issued to a correspondent bank requesting them to issue or reissue a demand guarantee directly to the beneficiary. So this is a bit like a back-to-back documentary credit. We actually have two guarantees in this instance. We have a guarantee going from the original bank, but he sends it to a correspondent bank and then asks the correspondent bank to reissue a guarantee in favor of the beneficiary. So now we have two guarantees instead of one guarantee. And there are a number of reasons why that might be the case, and we'll go over that in a moment. But obviously, one thing I'll make very clear right now is that when you have the indirect guarantee situation, the cost goes up, because now we have two banks, and two banks are each going to have a financial obligation, and each bank will charge a fee or commission for that obligation. So obviously an indirect guarantee is more costly than a direct guarantee. So depending on which side you're on, you know, whether your customer is receiving the guarantee or whether you're issuing the guarantee on your customer's behalf, one will be better than the other. Yeah. If your customer's paying the fees, then obviously direct guarantee is best. If your customer is not paying the fees and he's receiving a guarantee, an indirect guarantee reissued by you, then that's good for him. So it depends which side you're on, whether you're receiving or whether you're issuing. Now, why might a customer insist upon a local guarantee? So the local guarantee is the indirect guarantee scenario. Okay, the indirect guarantee where there are two guarantees. The first one issued by the correspondent bank to another bank asking the second bank to reissue the guarantee locally. So why a local guarantee? Why would the beneficiary insist upon a local guarantee? Well, at times the beneficiary will insist on issuance of a bank guarantee issued locally by the bank in the local country. And here's some of the reasons that they may insist upon that. First one is that the beneficiary is a government department or government ministry. So often a condition of a government contract is that the guarantee has to be issued locally. Second example, very similar, maybe the overall contract is a government related contract, and therefore again the condition associated with an underlying contract that is government related may mean that all of the associated bonds and guarantees that are related to that contract have to be issued by a local bank, cannot be issued by an overseas bank directly to to the beneficiary, have to come through a local bank and then be reissued by a local bank. Local regulations in beneficiary's country may insist upon it. So sometimes you even have legislation in place that says that any guarantees, bank guarantees issued must be issued by local banks. In a way, this is increasing revenue for local banks as well. It's giving local banks some business, because it insists if the guarantee has to be issued by a local bank, then that's good news for the local banks. Only they can issue the guarantees. Some other two reasons here: concerns regarding the applicant bank's credit risk and standing. So let's say, I don't know, maybe the applicant bank is in China. Maybe it's a small bank in China, and that your customer, who's the beneficiary of the guarantee, is not really familiar with the bank or the credit risk of that particular bank, and so he says, "I'd much rather that you issue the guarantee in my favour." So that would result in the indirect guarantee, the counter guarantee situation, or concerns regarding the applicant or applicant bank country risk. So let's say the contract or the guarantee is coming out of maybe Latin America or Africa, and again, your customer is not familiar with those countries, with the laws in those countries, with the economic standing of those countries. So again, he insists upon a guarantee being issued locally in his favour. So quite a number of situations where the beneficiary of the guarantee in your country may insist upon a locally issued guarantee. And you can talk to your customers about these scenarios and explain reasons why they should be insisting upon a locally issued guarantee. From your customer's perspective, having a locally issued guarantee in his favour is definitely better for your customer. There's no question. It will cost more, but it's certainly better, and you'll see why, some examples in a moment. I talked about significant revenue potential, and I wanted to share with you, sorry, not that one. I wanted to share with you an example of a transaction that I was involved with about 4 or 5 years ago, which was an indirect guarantee. So you may have heard of a country called Timor-Leste. And Timor-Leste is a country that gained independence from Indonesia around 20 years ago. So it's a very new country. It's only been in existence for around 20 years. But it has significant crude oil deposits offshore. So it's resource rich. And those resources are being explored, and there is a lot of oil exploration and extraction of crude oil being into your. So the country become quite wealthy because it's a small population. So it only has a population of around I think 1.5 million, something like that. Quite a small population, but it has a lot of natural resources, a lot of crude oil. So the country's become quite rich in the last 20 years, especially before the financial crisis, when crude oil was, you know, a lot more than US dollars, $100 a barrel, even up to $150 a barrel at one time. So the country became very rich, and it accumulated a lot of money, which the government basically kept in the sovereign wealth fund. And then the government decided, well, what are we going to do with all this money? And naturally enough, the government decides to spend some of the money on infrastructure. So they decide they want to upgrade the airport, they want to upgrade the port, they want to build some new roads. And the contract that we were involved in, the bank that I worked for, we were involved in the upgrade of the port facility. They were going to upgrade the port, and the contract, the port was owned by the government. The contract was valued at $350 million US. $350 million US. So it was a very large contract. And the contract went out internationally to companies internationally because there was nobody locally that could fulfill the contract. So it had to be companies were the only ones that would really be qualified and be able to complete the contract. And the winner of the contract was a Korean company. It was part of the Hyundai Heavy group, which is one of the large construction companies in Korea. There are several of them, but they won the award or were awarded the contract. So they're awarded a $350 million contract, but one of the conditions of the $350 million contract was that they had to provide a performance bond for 20% of the contract value. So a performance bond of 20% of 350 million is 70 million US dollars. So they need a performance bond in favor of the government, the Timor-Leste government, who are the people awarding the contract. They had to issue a performance bond in their favor for 70 million US dollars. And the tenor of the performance bond was 3 years, not 1 year, not 2 years, but 3 years. Now, one of the conditions for the performance bond was that it had to be issued by a local bank. And Hyundai Heavy, their bankers are all Korean bankers. And there's no Korean banks in Timor-Leste. So they had to come to the bank that I was working for and request our bank to issue the local demand guarantee. We agreed to do that against the counter guarantee from the Korean bank. And the pricing for that transaction, we charged the Korean bank 1.75% per annum for the 20 million. Sorry, for the, not 20 million, what am I saying? The 70 million over 3 years. Now, if you do the calculation, it comes to something like 3.5 million US dollars in fees. Every year, the annual fee for issuing or for supporting this demand guarantee was over $1 million US dollars. So one transaction generated around 3.5 million US dollars in fees for the bank that I was working for. And the risk that we're taking in doing that transaction is Korean bank risk. We were issuing the demand guarantee against the counter guarantee issued by the Korean bank. We're not taking risk on the Korean corporate. The Korean corporate is using his bank, and his bank is requesting us to issue the demand guarantee. So one transaction, and you can see huge revenue potential. So that's why, another reason I keep saying is why you should have somebody dedicated to these to this product, to market this product and to manage this product, because there is such a it can make such a difference to a bank's revenues. And you can see in the situation I just described with Timor-Leste and the government being the people awarding the contract, you can actually approach this contract from two different sides, or this demand guarantee. From a sales perspective, from marketing your guarantee product, you could approach it from two sides. One, you could be talking to the Timor-Leste government and saying, we understand, you know, issuing some contracts for large infrastructure projects. We would like to be issuing guarantees to you, you know, for performance bonds, for bid bonds, as you require them. when overseas companies are looking to bid, we are happy to issue demand guarantees in your favour. So please inform the bidding parties that they should approach us for issuing of the guarantee. So that's one side you can market to the Timor government. The other side that you can market to is on the FI side, because this transaction comes from a Korean bank. So if you have correspondent relations in place with a Korean bank, you can market to them. You can say, we are happy to issue guarantees in our market whenever you need to have a demand guarantee issued locally. We know that there's legislation in place. We know that the government contracts require local guarantees. Excuse me. We are happy to provide that service to you whenever you need it. So, two different sides in which you can market these types of transaction, and you should be alert to both sides to increase your chances of winning the transaction, because presumably other banks also are going to try and win these very lucrative transactions. Any questions on that little anecdote?
No questions, Roger, but I have to say that $3.5 million fees, that's
Unbelievable.
that's
Isn't
great.
it?
Unbelievable.
Yeah, one of the biggest fee transactions I've ever been involved in. Let's have a look at another one. It's another similar scenario, but there's a good lesson in this one. This is a real life example of locally issued versus cross-border guarantee. So we had here a case of an Italian company called Finmeccanica. So this is a Italian government, 30% government owned company, so partially government owned. And they were selling 12 VIP helicopters to the Indian government. So the Indian government is buying helicopters from Italy. The contract required various bonds: advance payment guarantee, and warranty guarantee, totaling 256 million euros. And that, again, a very large contract for these 12 helicopters. The APG, the advance payment guarantee, and the payment guarantees were issued by Deutsche Bank Milan directly to the Indian government. Because remember, the Indian government is buying these helicopters. So the APG and the PGs issued directly by Deutsche Bank Milan straight to the Indian government. Maybe advised through Deutsche Bank in India, but no reissuance, no local guarantee. However, the warranty bond was issued by Deutsche Bank Frankfurt, but it was reissued locally by the State Bank of India. So the warranty bond was an indirect guarantee, and the local bank was the State Bank of India, issuing the guarantee at the request of Deutsche Bank Frankfurt. Okay, well, that all seems fair and reasonable. Now, the problem was that when the Indian government called on all of these PGs in 2013, it was alleged that Finmeccanica had won the contract by using inappropriate means. In other words, there was some corruption and allegations of payments, corruption, bribery happening in order for the contract to be awarded to the Italian Finmeccanica. As a result, they made claims under all of these bonds, but only the State Bank of India warranty bond was paid out, and that was only for 37 of the 256 million, as that was issued by the State Bank of India. So that one got paid out quickly and cleanly by State Bank of India. However, all of the other bonds were not paid out, as they were issued directly into India by Deutsche Bank Milan. So remember, the counterparty now, or the risk party that the Indian government has, is Deutsche Bank Milan. What do you think? Deutsche Bank Milan is a good bank. Deutsche Bank is one of the largest banks in Europe. Italy's a good country, the European Union. Well, the problem was that the Italian court issued a court order that blocked the payment under Italian law as Finmeccanica sought an injunction. So Finmeccanica went to the Italian court, got an injunction which prevented Deutsche Bank Milan from making payment under the APG and PGs. Well, then the Indian government had to go through the court system in Italy to try and claim the monies owed to them. And eventually they received payment after a long and expensive legal process. So the good news was they did finally get paid. They finally got their money back. But it was a long and expensive legal process. So the lesson learned in this real life example was that the Indian government should have insisted that all of the payment guarantees and APGs were reissued by a local bank. If they'd all been issued by State Bank of India, then they wouldn't have had to go to court. They wouldn't have had to spend a lot of money and time in trying to get. And the last point I have made there, if it had been the other way around, in other words, if the Italians had to take a court action in India, if the whole thing had been the other way around, they would still be waiting, because I'm sorry to say, but the Indian court system is renowned for its bureaucracy and its slowness. And some things in India going through the legal system can take 10 years, 15 years, 20 years before they can be resolved. So another reason why it's highly recommended for beneficiaries of this type of instrument to insist upon local guarantees. If you insist upon local guarantees, then you're in a much stronger position, even though you have to pay more in terms of fees, because you've got two guarantees instead of one guarantee. In the long run, you're going to be a lot better off. So always wise to recommend to your customers, and you can use this as an example to your customer. Don't accept a cross-border guarantee. Always insist upon a local guarantee, and we will be happy to provide local guarantees in your favor if you offer this product. So some good lessons learned from a real life example. And here is just a pictorial example of what the counter guarantee transaction flow looks like. Company A, well, there's an underlying transaction, of course, to start with between the two parties at the top. But then the principal will approach his bank in his country and request his bank to approach a correspondent bank in the country of the beneficiary, country B, to reissue a guarantee on his behalf. So step 2, request to his local bank then dealing with its correspondent bank in the country of the beneficiary, requesting that bank to issue a local guarantee, a demand guarantee in favor of the beneficiary. So you can see two guarantees. We have guarantee at step 3 between the two banks, and then step 4 between the guarantor bank and the beneficiary. Now, when we look at these, any type of guarantee, we should think about what needs to go into the guarantee, and basically there's 4 components or 4 areas in which we need to include or cover in the guarantee. The first one is maybe fairly obvious: applicant details, beneficiary details, and the underlying relationship or transaction between the two. So that would be the first part. The second part would be the actual undertaking to pay, the limits of the undertaking in terms of amount, expiry date, etc. The next part 3, is what is needed for a valid claim, a demand to be made. Is it unconditional? Is it just simply a statement of default, or is there some other supporting documentation that's required, which would make it conditional? Other documentary and any other documentary requirements, so that maybe not required. And then part 4, all of the standard clauses that you would need to put into such guarantees. There are many standard clauses that you may incorporate depending on the circumstances. We'll go through some of those in a moment. And then which rules are you going to use? Sometimes we have local law being applicable to guarantees, bank guarantees. Although obviously there's a risk with local law because you don't necessarily understand what the implications of local law might be. You know about your own country, but you don't know what it is in an African country or a Latin American country. So local law can be risky. So international rules that are available to you are ISP 98, International Standby Practice 98. So that's an ICC publication. It's been around since 1998, so it's over 20 years old. Or more recently, URDG, Uniform Rules for Demand Guarantees, ICC publication 758, which is also very specific for demand guarantees and commonly used as the governing rule for this type of product. So what is better? Well, most common is local law, but URDG is becoming increasingly popular. The problem is when the guarantee is subject to local law, are you really aware of the effect of the law that will be applied to the guarantee? And here's some weird and wonderful examples. First one, laws that state that the expiry date of the guarantee is the stated expiry plus up to 30 years. So the liability is not extinguished for another 30 years. And of course, that has capital implications, that has pricing implications. Certainly you wouldn't want to have that past the expiry date. Or laws that state that the expiry date of the guarantee is when the original guarantee is returned. So the original guarantee has to be returned. Cannot be cancelled unless the original is returned. And it's amazing how often people lose these things, believe it or not, especially when the tenor of the transaction is maybe a year or 2 or 3 or 4. It's very easy to misplace, and then well, how do you cancel it if you can't get the original back? Or laws that state that the expiry date of the guarantee is the stated expiry date plus a grace period, similar to the first example where it was 30 years, but in this case maybe, I don't know, 6 months, 1 year, who knows. So different laws, different countries, and that's why URDG is preferable, because URDG defines these things and stipulates when a guarantee can be considered cancelled. So I would recommend that if you are going to offer these products, that you use URDG as the governing rules, and it's better suited than ISP 98. ISP 98 is for standby LCs, whereas which cover many different types of guarantee, whereas URDG is specifically for demand guarantees. So I think URDG is the best choice. Some standard clauses and disclaimers that you may encounter. One called a pay and walk clause. So an example of a pay and walk clause is something like, notwithstanding anything stated in this undertaking, XYZ Bank has the right to terminate it at any time by paying the beneficiary the amount or the balance outstanding of the amount or any lesser amount that the beneficiary may require. So Why do you want this clause in there? Well, banks like to have this clause in there in case they see a problem in the future. If they decide to liquidate the situation or to bring forward the event by making a payment under the guarantee so that they can walk away from it. Maybe they think that by not doing so, they could increase their own risk in the transaction. There may be a risk that they might not get reimbursed by the applicant, or maybe the applicant's going bankrupt. So there could be a number of reasons why a bank would want to crystallize its obligation and pay early, and then take advantage of the security that it has from the applicant to make sure that it doesn't suffer any loss. So that is a common clause in many guarantees. You can expect to see it in quite a large number of guarantees contain that clause. It just gives more flexibility to the bank issuing the guarantee, the guarantor, in terms of closing out its liability under the transaction. Another example, non-assignability clauses. This means an example here is this undertaking is personal to the beneficiaries. No beneficiary may assign, transfer, charge, or otherwise deal with its rights under the undertaking, and XYZ Bank will not recognise any purported assignment, transfer, charge, or other dealing. In other words, only the beneficiary can take advantage of the guarantee. He cannot pass it on to another party. So it's only for the beneficiary's benefit. And that's increasingly the case with concerns regarding AML and sanction checking, because if he passes it on to a sanctioned party, that would be a problem for the bank. So they only want to deal with the beneficiary. They know who the beneficiary is, and only he can benefit from this guarantee. He cannot pass it on or assign it to a third party. So that's another example. Then evergreen. Evergreen is often used when the tenor of the guarantee that is required may be a long tenor. So maybe there's a contract that's going to be going for 10 years. Well, not many banks can take credit risk for 10 years. It's just too long. So they can't issue a guarantee with an expiry date of 10 years. They prefer to. And this means a guarantee which includes a provision which automatically extends the expiry date of the guarantee for a specified period within some period of time in advance of the applicable expiry date. The bank gives notice to the beneficiary to the effect that such guarantee will not be so extended. Let me just explain that in plain English because it's not very clear. If we had a 10-year contract, you can't issue a guarantee for 10 years. You can only issue a guarantee for 1 year. But you issue a guarantee for 1 year and you include an evergreen clause, and the evergreen clause says that unless you hear from us 30 days before the expiry date, the guarantee will automatically be extended for another 12 months. So if you don't give notice that the guarantee is going to be cancelled more than 30 days before the expiry date, the guarantee automatically gets extended for another year, and so on and so on and so on. So then the beneficiary can be confident to know that, okay, well, it may only have an expiry date of 1 year, but I know it's going to get extended for another year, unless I get notice 30 days before the expiry date, in which case I can make some alternative arrangements. If necessary, I can make a claim under the guarantee. So it gives the beneficiary the protection he's looking for when the expiry date of the guarantee is only 1 year, but the contract is actually over a much longer period of time. So that is an example of an evergreen clause, and again, very commonly used. And then the last category, or the last example I've got there, is the sanction disclaimer clauses. Now, of course, everybody has to vet transactions very carefully for sanctions and for potential money laundering and potential problems with individuals, companies, countries, corporates. You have to review the whole transaction, and if there is a problem with a sanctions breach, then the transaction may become invalid. So you need to insert into the bank guarantee a warning that the transaction will be subject to scrutiny at the time. If there was a claim, it will be subject to scrutiny, and if there is a breach of a sanction, of an international sanction that the bank has to adhere to, then payment will not be made. So that again appears in a lot of guarantees these days to protect the bank in the event that there is a sanctions breach at some time in the future. So there's some examples of clauses to consider inserting or using depending on the circumstances. Now the last section is on credit exposure under these guarantees. Now clearly, if you're issuing a guarantee on behalf of your customer, a corporate, you will need a credit line on your customer, on the corporate. That's quite obvious and straightforward for the tenor of the transaction, which may be 12 months or maybe longer. So if you're issuing on behalf of your customer, the applicant is your corporate customer or your individual customer, you need a credit limit for the amount of the guarantee. However, what about guarantees where you're receiving a request from an overseas bank, from a correspondent bank, as in the case of the Timor-Leste transaction, where the bank in Timor-Leste received a request from a Korean bank to issue a local demand guarantee. You need to have a credit limit on the requesting party. So you need to have a bank or a counterparty limit covering the amount and of course the currency, because the currency could well be a foreign currency, and the tenor of the transaction. So if they ask you to issue a guarantee with a 3-year tenor, you need to have a 3-year credit approval. And if it's in US dollars, you need to accommodate the US dollars, and there may be some currency fluctuations in that time. So the first thing you're going to need is a limit on the counterparty, the bank requesting you to issue the guarantee. The next thing you're going to need is a country limit, because it's not only the bank that you need a limit on, it's also the country in which it's located. So in the example of the Korean bank, it would be a limit on Korea, because you are taking country limit exposure on Korea. You're not only taking risk on the bank in Korea, you're also taking country risk exposure, because there could be a problem suddenly with Korea. There might not be a problem with the bank. There could be a problem with Korea, which prevents payment from being made. So they're two different things, bank limit and country limit. One rolls up into the other, obviously. So one approach could be to look at a list of approved banks only. So you might say, well, we deal with China a lot, or we deal with Russia a lot. We're comfortable with the following banks. Four or five banks, the big five in China. I mean, the credit risk of the big five in China is probably very low indeed. So you could easily agree to take credit risk on the big five banks in China. Equally for Russia, you may be comfortable with dealing with a number of Russian banks. So come up with a list of banks that you can basically get pre-approved credit limits, where your credit department will be comfortable with the risk of the bank and the country, Russia and Korea, for example. Another alternative or another approach is to look at MNC banks. So let's say, I don't know, Barclays Bank or JP Morgan or Deutsche Bank, that you may be comfortable dealing with large MNC banks, multinational banks, that is, multinational banks, and base it upon the country ratings and the counterparty ratings. So Deutsche Bank Italy, you can see what the country, what the external country rating is from Standard & Poor's or Moody's. Equally, Deutsche Bank has a rating for short, medium-term obligations. So you could use that as a way of assessing the credit risk for both the country and the issuing bank. And for MNC banks, basically come up with a pre-approved list of MNC banks, similar to the idea above, but perhaps more for multinational banks across a number of different countries. And then the other alternative, which is often used, is sell down or risk participation. And what is that? That is where you find you have a transaction, a request from a bank, but you don't have credit appetite for that bank, or you don't have country limit for that bank. So therefore you are unable to do the transaction. What you could do is look to find somebody that's willing to take that risk on for you. Somebody that's acceptable risk to you, but willing to take that risk on. And in places like London and Singapore, there is an active secondary market for this type of risk. So you could go to London market and you could look at your correspondent in London. Let's say your correspondent in London is HSBC, and you could say to HSBC, I want to sell you down this African bank risk. Will you support me and buy it from me? And they say, yes, happy to do so. And the price is this. So that would be a sell down or a risk participation. You find an acceptable counterparty in London or in Singapore that is willing to take the risk of the transaction on, and you can then transfer your risk on to the party taking that risk from you. Of course, you will reduce your revenue in that situation because you will have to share your fees, a large part of your fees, with the party buying the risk, but you will keep a margin for yourself, and you'll still be able to do the transaction. And you know, if the transaction did generate revenues of $3.5 million US and you were able to keep 10%, you'd still be very happy, I'm sure. $350,000 for a transaction is still an excellent fee. So that is another alternative especially for larger transactions. That basically concludes today's session. Just over an hour. I hope that's given you a good feeling for this product, and you know, I think it's an excellent product. It's one of the products that has some of the most interesting transactions behind it. But of course, as I said at the beginning, there is a lot of risk associated with it. Not only credit risk, but also operational risk. You need to have good operations people. You need to have good legal people that make sure that you draft the documentation. The guarantee wording is carefully drafted, that you have counter indemnity in place from your customer, so that you have a clear right to claim from your customer in the event that you get a claim. So you need to have excellent documentation and in place to do this product, and experienced staff to do this product. But if you have that, then they will more than pay for themselves, because there is a lot of opportunity around this particular product in terms of revenues. So anybody have any questions?
No, Roger, no questions, but in our bank, the responsibility for the issuance of bank guarantees belongs to the loan department. So for me, this session was has a lot of interesting information, because I never how to say, I never had any experience of issuing bank guarantees, but also saw Swift messages, MTC 760 or 799, but never had any experience of being in that deal.
Yeah, so a lot of banks do have it under loan department. I think it sets better under the trade department if the trade department's properly set up, because they're closer to LC transactions than they are
Yes.
to loan transactions. So,
Yes.
but you need the expertise in the legal side, which may
Mhm.
not exist in the trade department. So that's one thing you need to certainly make sure you have. But then, yeah, I think because you're using ICC rules, because you're using Swift messages,
Yes.
to me, it sits better in trade operations than it does in loan department.
Mhm.
But you also want somebody responsible for driving the whole product in terms of revenue and sales strategy. And you know, as I said, one of the best ways to market this product is actually on the FI side. So your FI people need to be talking about this product to other FIs, to other correspondent banks. So it covers a lot of different, and it needs coordination. If it's just left to one little area that just responds to the request every time there's a request and that's it, then you will not fulfill the potential of the product. So yeah, maybe you can go to your management about moving it to the trade operation.
No, as I know that in order to issue bank guarantee, the bank guarantees have to be backed by securities.
Yes,
That's why the loan department
Yes.
responsible for that dealing.
yes, yes. Well, that's true. You know, you wouldn't do it unsecured, but the guarantee or
Mhm.
the security could be just another guarantee from another bank.
Mm.
So, you know, it's not bricks and mortar security. It could be just simply another piece of paper from another bank, subject to international rules. So,
Yes.
you know, anyway, I'm glad it's given you something to think about, which is good.
Thank you. Thank you.
All right. Has Camilla got any questions?
Camila, can you say questions?
Okay.
Everything is also understandable for her.
Okay. Very good. All right. Well, that's it for now. I'm hoping. I really hope that we can all meet in person in the not too distant future. I'm hoping that once the COVID situation settles down next year,
Yes.
hopefully, I'll be able to travel to Uzbekistan and come and meet you face to face and do some more training. Face to face is better than,
Yeah.
or in person is better than doing it over the internet.
We're glad to see you here in Uzbekistan, and we'll be happy to have any lessons, not only from Zoom, but
Yes,
here at our office.
that would be much better, and we can get many more people involved, I hope.
Yes, yes.
Good. Okay. Well, that's it for now. If you have any follow-up questions, don't hesitate to reach out to us. And Marutha will ask you for some feedback, I'm sure, on the session. But yeah, if you have further questions at any, don't hesitate to email us.
Thank
So
you
bye
so much,
for
Roger.
now.
Bye bye.